I've titled this The Presumption of Innocence in the UK: Principle versus Reality. The presumption of innocence is meant to be one of the cornerstones of the UK justice system. It is written into our legal tradition, echoed in our courtrooms, and taught as a fundamental safeguard of fairness. Yet, when we look closely at how justice is experienced, not in textbooks, but in the real courtrooms and in the court of the public opinion, we see a troubling gap between the principle and the reality. In theory, every defendant enters a courtroom innocent. In practice, many walk carrying the weight of suspicion long before a single piece of evidence is tested. This is not because judges or juries consciously reject the principle, but because the wider system, media, public discourse, and even courtroom culture often frames defendants as people who must prove their innocence rather than people whose guilt must be proven by the state. This imbalance matters, it really does. It shapes how defendants are perceived, how defense teams must operate, and how the public interpret high profile cases. We've got a prime example at the moment with Andrew Mountbatten Windsor. And it raises a serious question: are we truly upholding the presumption of innocence, or are we merely reciting it while behaving as though guilt is by default? The current public conversation about Andrew Mountbatten Windsor illustrates this tension. Whatever one thinks of him personally, the fact remains he has not been convicted of any crime. Yet the sheer volume of media coverage has created a widespread assumption of guilt before any evidence has been tested in a court of law. This is not a defense of him as an individual, it is a defense of the principle that no one, whether a prince or an ordinary citizen, should be tried and sentenced by public opinion before they are tried in a courtroom. When media narratives dominate, they shape the mindset of potential jurors, influence public pressure on institutions, and create an environment where the defense begins at a disadvantage. A defendant who is presumed guilty by society must fight not only for the prosecution's case, but also the shadow of public judgment. This is not equality of arms. This is not justice. The presumption of innocence is not just a legal technicality, it's a moral commitment to fairness. It protects the vulnerable, the unpopular, and the misunderstood. It ensures that the state must meet a high burden before taking away a person's liberty or reputation. And it reminds us that the justice must be based on evidence, not emotion, on facts, not headlines. If we allow media narratives to replace due process, we risk the injustice system into a performance rather than a safeguard. We risk punishing people not for what they've done, but what the public has been led to believe. And once that door is open, it does not close easily. So the challenge before us is simple but urgent. To make the presumption of innocence real again, this means responsible reporting. It means resisting a rush of judgment. It means remembering that allegations are not convictions. And it means ensuring that every defendant, famous or unknown, enters the courtroom with the same protection our justice systems promise them. The presumption of innocence is only powerful if we honour it, not just in law, but in culture. If we fail to do that, we risk losing one of the most important safeguards of a free and fair society.